Good morning, afternoon, or evening, depending upon where you are in the city. Welcome to From the Halls of Justice. And this evening, we are honored to have with us Alexandra Lavinsky, and she is an awesome family law attorney. You have a background in civil and entertainment. And Alexandra is my co-host, helping me with From the Halls of Justice, because today, for our guest, you are going to be impressed. We have the Superior Courts with us. We have the Honorable Judge David Samuel Cunningham III. And also the Honorable Judge Rudolph Diaz. So we have dependency court and we have probate.
Yes.
So we are going to be well educated in this show. Sit back, relax, and grab a pen and pencil. You're going to be happy that you did. So, Alexandra, how long have you been an attorney? And tell me about yourself just a little bit.
I've been practicing for 12 years, and now I focus primarily on family law, but my background in civil litigation has really enabled me to understand how litigation works, and that makes me a strong litigator when it comes to family law.
Yes, you are. You're a very strong litigator. And what encouraged you? You started out as an attorney with a wonderful gentleman. Can I say he was your uncle?
Yes.
Okay. He was your uncle. And then you started your own practice. So what made you start your own practice?
I was ready to go on my own and take the kind of cases that I really wanted to focus on and practice the kind of law that I wanted to practice. And that has given me a wonderful opportunity to handle all different aspects of family law, from dependency court through adoption, through the entire divorce process.
Wow. Well, you're going to assist me in interviewing the Superior Courts, and I'm just really honored to have these two gentlemen here. Both of them are well-known judges, and they do such a fabulous job in the community. So, if you don't mind, may we start with the Children's Court?
Fine. I'm ready for it.
Okay. Judge Diaz, would you mind telling us a little bit, how did you become a judge? What happened?
Well, and I wouldn't say it's a fluke, but I used to be a federal public offender. This was back in 1980, and one of the judges took a liking to me, and he just approached me and says, "Have you applied for a judgeship yet?" And I says, "No." He says, "Get going." And so I called the governor's office, and I received an application form, and I sent it back, and with all the right support that developed through the process, I became a judge. And my first assignment was a municipal court judge in the San Gabriel Valley, and I sat there for 19 years. Then we merged. The courts merged from Muni and Superior to one trial court. It became Superior Court, and I began juvenile delinquency, where I worked for 7 years, and then I took the step, went downtown, and became a family law judge for 4 years, and now it's been 4 years since I've been in dependency.
So how long have you been a judge?
Almost half my life. 34 years.
Oh my God!
I was a pretty young man. I was 37, I think, when I was appointed.
Wow.
So
That's extraordinary.
yeah, and I'm glad they put me in municipal court to start off with, because, I think that the life's experiences are very important for a judge, and so over that time, and that's kind of how I feel about where I'm at right now. I mean, I've been here a long time. I've had 34 years of judicial experience, and it's always there. What decisions that I make and cases that I have to address, it's just not dependency. It's really about everything else that's going on in those cases, and also about my experiences as a judge and how I've made decisions over the years.
That's amazing, 34 years.
Yes.
Okay, so Judge Cunningham,
Yes.
how did you become a judge?
Well, originally went to, when I was in college, I joined the Washington, D.C. semester that USC had as a special internship. USC. And I ended up working for the executive director of the Courts of Appeals in Washington, D.C.
Wow.
And he was an extraordinary gentleman. His name was Charles Nelson, and he was in charge of Navy intelligence before he became executive director of the Courts of Appeals. And this was in the mid-'70s. I was 20 years old, and while I was there, the executive director asked me, Captain Nelson, as we called him, said, well, who do you want to meet? And so I wanted to meet judges, because at that time it was right after the Watergate trials, and John Sirica was the judge at the district court, and Spotswood Robinson is an African-American lawyer who subsequently became a judge. And then I had on my wish list the incredible, legendary Thurgood Marshall. And he said, don't worry, I'll make it all happen.
Wow.
And I had a chance to meet all three of them, and it was an extraordinary experience for me, because I said, these are the types of people who go into law and become judges. This is what I want to do. And that started me down that path. Each of those individual judges met with me. They asked me what were my interests from a career perspective. And one of the things they left me with is to tell me, you can do whatever you want. And I believed them. And of course, I've also, as a colleague, had Judge Diaz, and similar personality. The personalities of people who I've met that were judges, I found were they had a intellectualism, they had an openness, and they had a desire to want to help people. And that their interest in the law went beyond the economic returns. It came down to justice and fairness and what they can do for others. And that drove me, that I felt ultimately at some point in my career that's where I wanted to head. And after practicing law for almost 30 years, I got appointed in 2009. So I've been a judge almost 6 years now. And I've loved every minute of it. One of the best jobs I've ever had.
You're an extremely impressive man. You really are.
Thank you.
Judge Diaz, tell us a little bit about what is dependency court.
This is the area of law that addresses issues relating to children who have been abused or neglected. We also, on the lighter side, we do adoptions. But most of what we do is dealing with children who referrals have been made who may be abused or neglected. We try to focus on protecting the child, and we also focus on trying to reunify the child with the family. So between those interests, we try to figure something that is best for the child.
And how does one open, or how does a dependency case begin?
Most cases come from referrals, and a call from a neighbor, a relative, will bring out an investigation by social workers, police, which are mandatory reporters, may be involved in an investigation, a criminal investigation. For example, I'll give you some quick examples. A mother or father are arrested for trafficking in narcotics. They go to jail, and what happens to the kids? Well, they have to come and they have to find a placement. And the first priority is to try to bring them home if there's one parent who's available. Second is to place them with relatives. The next is close friends, and if it's necessary, then to put them in foster care for the time being until we can continue to investigate placement for the children. Other mandatory reporters are teachers, doctors, and nurses. They will call when they see something suspicious, and they're required, as I said, to call the Department of Children and Family Services, who then initiate an investigation. And it's not necessary that a petition be filed on every case. If it's a case that might be some physical abuse, but not serious, but still very significant enough to address, they try to do a voluntary family maintenance plan. That is to, if the parents are cooperative and again the allegations are not that serious, perhaps they can keep the kids and they can set up a program, a case plan for the family, have the parents attend parenting classes. If there's substance abuse, maybe drug treatment, and try and keep the family together. But in the more severe cases, then the department will seek the approval of a judge called a removal order, and have the children removed, and the petition then is filed, and the process becomes formalized. Also, if the voluntary plan is not working because one of the parents or there's repeated allegations, and then that will also be result in a new petition being filed as well. But even after the petition is filed, if it's doable, children still might be released once again to the parents if we can see after a better investigation, a more thorough investigation, that maybe we can give it another chance, keep the kids together, because removing children from the parents, and even though the parents may be abusers, that's still that's their parents, and that's the people that they love, and that's the people they know that take care of them, and it's a traumatic experience for them. You can see that in court when they come in, and when the children have been removed before the first arraignment hearing, the parents come in to the front door, the children come in from the side, and you can just see them running to each other, embracing, and the abuse could be very severe at times, but still the bond is pretty strong. So it's a very difficult assessment that the court has to make with the assistance of course, the department and the social workers.
Now, can anyone report child abuse?
Yes, and I think, if I can remember the number off the top of my head. Do you have it there?
Let me help you.
All
It
right.
is 1-800-540-4000.
Yes.
So once again, if there's child abuse and if someone suspects that there's child abuse, the telephone number would be 1-800-540-4000.
Now, it should be noted that a person who reports abuse can do so in confidence. They do not have to be identified if that's their choosing. They may be later on requested to come forward and testify, but no one's going to force them. But it will at least initiate an investigation, and social workers will come out and conduct the investigation. And it may be overstated. It may be something that can be easily explained and won't require a petition be filing. But when somebody sees something, even on the street, for example, sometimes you see something in the street that just is horrific, and you call law enforcement, you call somebody to come out and intervene to protect the child.
If efforts fail to provide voluntary services, then what happens?
Well, then the department has to decide whether or not it wants to file a formal petition. And when they come to court, attorneys will be appointed for the child, for the department, because they have their own attorneys, which is the county council. And then the parents will be provided lawyers as well. Now, I'm giving you the simplest scenario. Sometimes, there are 10 children in a family.
Wow.
Right? And sometimes there are multiple fathers, perhaps, or multiple mothers. And so you can have 10 lawyers sitting in one case. And the children may have different interests because they're different. There's a difference in ages, because maybe some of them have not been abused. Maybe some of these children can be returned to the father, who maybe hasn't been involved, but nevertheless is still a better resolution to have the child returned to a parent. So it gets to be rather complex at times when there are multiple children, multiple parents, and then the legal guardianships are involved in these sometimes too. They come forward, so grandparents want to be involved, and they want to be appointed, as they call it, de facto parents. They want to be given a status, not quite as strong as a parent, but at least a status to be able to be involved in the proceedings. And sometimes that happens.
So when the petition is filed and then there is detention of the children or release, who are they released to, and how do you make that decision?
Well, again, there's a preference. The preference, of course, is to return them to the parents. But if they've been through a voluntary a plan and it hasn't worked, it's unlikely that the children will be returned to the parent. Or maybe another parent who is what they call the non-custodial parent. A father who visits on weekends may be an appropriate parent to return the children if there's space available and father is not homeless. Sometimes that's the situation, but if it's appropriate to return the child to a non-custodial parent who is not offending, then that child can be released. Next in line would be relatives, usually grandparents, sometimes close aunts, uncles, cousins sometimes, and so we're trying to keep a family together as much as we can. Sometimes distance is a factor. Maybe grandpa is in another county, and one of the plans that we would like to see is that the children will continue to have parental involvement in their lives, especially during the reunification process. So, but if a grandparent lives in another county like San Bernardino or Kern County, it becomes very difficult. So it may not be the best choice to remove them and have them, because the parent won't be involved in visiting with them. And then ultimately, as I said, there may be a close friend that as close to the children, and the children have some kind of a bond to that friend. That'll be, and then the next case is going to be foster care, foster parents.
And what is the adjudication stage, and what happens or can happen at the adjudication hearing?
Well, at the initial hearing, it's called the detention hearing and the arraignment, the petition is read to the parents. Counsel is appointed, and the court, even at that early stage, will begin to order the department to provide services. If the parent is in need of drug treatment, we'll make an effort to get them into drug treatment, individual counseling for the children as well, and then the adjudication follows usually within 3 to 4 weeks. Sometimes it takes longer. The purpose of the adjudication process is to determine whether or not the allegations that are charged in the petition are true. And if the department can't prove them, then of course the petition will be dismissed. Maybe some of the allegations won't be proved. And the burden of proof is not as high as it is, as you would say, in a criminal case where the burden is beyond a reasonable doubt. In dependency, it's the same as a civil, because actually dependency is civil law. The burden of proof is by preponderance of evidence. So the allegations can be proved also by hearsay, which is reading of reports. The parents have a right, as do the children, have a right to cross-examine the reporter of the report, any witnesses who are named in the reports as well. So a trial could last anywhere from 20 minutes to weeks. It just depends on what the issues are, and so they could last. After that, once the court decides whether or not the allegations are proved, if it's dismissed, it's dismissed. Everybody goes home. If they are sustained, and then to decide now by way of disposition, will the children now be released? Will the children continue to be detained away from the offending parent or parents? Or will the children remain with whomever they've been placed, or someone new? Sometimes a resolution might be used to place the children with family in another state. And that could happen as well, where they've had a close relationship with a grandparent or uncle. That decision could be made. But that makes it difficult for the parent to reunify with the child. So that's not something you will select initially.
And is an incarcerated parent eligible for reunification services?
One thing the appellate courts have said is that incarceration in itself does not take away your parental rights. So, if there's a child who is under the age of 3 when the petition is filed, a parent is entitled to at least 6 months reunification services. If the children are all 3 or older, then the parent is entitled to 1 year reunification services, provided that they are maintaining contact with the children or making a reasonable and serious effort to comply with the case plan.
And if the court determines that termination of reunification is appropriate, then what happens?
What the court does then is set it for what they call a selection, a permanent selection hearing pursuant to section 366.26. And the court will then identify whether adoption or legal guardianship or whether it's just a permanent placement. And if a child is older, 16, 17 years older, it's going to be difficult to find an adoption home or maybe even a legal guardianship, but not always. So that will be a removal and placed with, it could be relatives, but it also may be foster care. It could also be a home for children that we have, which is the least favorable. Because those are the most severe cases where the parents have no contact and children need a lot of services when they get to that level. So, but a parent, even though the court is setting this matter for a hearing, and at that point the court has got to notify any possible parent who's around. And sometimes there's been a parent who hasn't been around for decades or 10 years, and we got to find them. We got to let them know that the court is not making a decision that could ultimately lead up to an adoption. If the younger the child is, the more the adoption is the favored disposition in the case. And if there's close relationship with family, then we're going to look at legal guardianship.
What happens to a child who's in the system and they turn 18? And they
Well,
haven't been
I'm glad
read?
to see the change that I've seen. I know when I first became a judge, and I used to read about, I wasn't involved in dependency, but I used to read what happens in the other areas, and it was basically a kid turned 18, I gave him a couple $100 and said, good luck. But now that's changed dramatically, and I'm so glad to see that. Now, and under recent law, what they called AB 12, it extends the opportunity to provide services to children until they're age 21. So they can stay in the system but they have to be doing something. They have to be in the place that's appropriate, and the place that's appropriate is not as restricted as a foster home. In other words, if you have a good friend and they inspect it and assess it and say, well, this is okay. You can live with an older person who can supervise you, but they don't really do that because they're 18. They're really adults. But you either are going to be working, or you're going to be in school, or you're going to have some other plan, and then you can stay until you're 21. This is just great. We have about 1,100 to 1,200 in the county of Los Angeles who are in this area. We got 28,000 kids who are now before the court in our system. So we obviously have the biggest. We have the biggest everything with such a big court. Yeah. So over you go. And we have 20 judges in dependency, and 2 of them are assigned.
20?
20 judges who do dependency alone. 2 of them are in Antelope Valley. And there's pretty heavy load out there as well. But not all cases stay there. Many cases will end up down in Los Angeles for various reasons. Maybe the parent will move and the child's placed here. And then we have 18 courts here in Los Angeles. The location for dependency is actually in the city of Monterey Park. And it's a new building, relatively new building. It's about 20 years old, but to me that's new. And it's a really nice place, and it's children oriented. I mean, they paint it, the judge's bench is not as high as it is in the other courts, and we have little children's things on the walls. And we have one thing that I'm really glad to have seen is we give them teddy bears.
Oh.
Every child, if you just think about parents who come into court are very tense anyhow about coming to court. Can you imagine a child who has been traumatized by maybe a parent or by just the whole process, and they're sitting there, and sometimes it's the most darling thing you can see is to see a kid who can barely reach over the table, and then you give them a teddy bear and they just grab it, and then they feel something soft, something warm, something that now also belongs to them. So I'm really glad to see that teddy bear program come into being, and it's all donated stuff. So I'm really, really grateful for that. And it really helps. It really does help these children. And the ones that come to court are about like 3 or 4 years old to about 18. But the babies don't come because obviously they don't need to be there for that. They don't
So
do it.
how do you get involved in the teddy bear program? I mean,
Well, somebody. I mean, I think I know a person who had a lot to do with it. I'll give her credit because I'm going to go to her dinner this coming Friday. Anyhow, Ernestine Fields.
Exactly. Yeah.
She's been given credit for it, and she's been able to obtain donations to buy it. And we've got 20 courts that are, provided these boxes and boxes of teddy bears,
that's fabulous.
and they change colors. They go with the season. During Valentine's Day, they're Christmas or a different color. So they're very sweet, and I say it warms my heart to see kids with a smile on the face, notwithstanding everything else that they're going through, and they get it because of that little teddy bear.
They've named Ernestine Fields as the Person of the Year from Metro.
That's why I'm going. I got it.
Oh, I didn't
want
know.
to honor her.
How wonderful.
Yes,
She deserves it.
She certainly does.
that's awesome. That is really awesome.
She's an amazing person. She's been doing this for a very long time.
Well, you know what? It's really exciting to see two gentlemen and to know that you have been serving the community over 30 years, and your heart is so into caring about these children. That is absolutely awesome. And so once again, as we're almost wrapping up the show, and I want to thank Alexandra Lavinsky for being here with me. There's a telephone number that if you're concerned about a child that's being abused, the telephone number is 1-800-540-4000. And once again, 1-800-540-4000, 4000. And I thank you for being on from the Halls of Justice. And is there any hot point that you might want to give in like 30 seconds?
Just how lucky we are to have wonderful judicial officers that care about their cases and read and know. It is so important. Justice cannot happen without good judges, and that's what we have, and we're so honored.
And that's why this is from the Halls of Justice, and we are so happy to have the Superior Courts with us today. And yes. Tune in next week. We'll still be here, and we will be interviewing the Honorable David Samuel Cunningham and
Sir Meyer.
And thank you, Judge Diaz, for taking the time to come. And we really, really appreciate you. And the Teddy Bear program is a real inspirational gift to all of us. Yes.
Could I add, one of the premier assignments is the dependency work. And the reason you know it is because our best judges, the presiding judges, who can go anywhere they want, choose dependency. And listening to you, Judge Diaz, and from what I've heard the other judges, what they do there, the judges themselves love the work. And I'm presuming from what you've said that you probably feel that way, and I can see and appreciate where it comes from because you're doing some good for children.
Well, as I said, with 34 years, I've seen a lot in this business. I've done a lot, and this is. I feel like I've come full circle, and I feel that I'm doing some wonderful things too.
You are. You're absolutely fabulous. You'll have to come back. Thank you for joining us from the Halls of Justice. Tune in next week.
Thank you. All right.
That was good.